of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Thanks for joining us. Today, we're talking about the 5 changes for your creative finance contracts. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like and subscribe to our channel. We are on YouTube, Facebook, and X. You can find us on all of those platforms at the handle @InRem Podcast. That is @InRem Podcast. Also, you can download an audio version of the podcast, whether it be Spotify, Apple Podcasts, or just about all of the major podcast platforms. Download it, leave us a review. You can do it for free. You can listen to us while you're cleaning the house or whatever you do. Make sure to download that when you can. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So our legal update today is talking about assignment provisions. And it's actually a very relevant topic for today's show, because what I found is investors who are acquiring property from, sellers, homeowners, they're very good about making sure that that purchase contract is assignable. So they make sure that their assignment provisions are in there, that, if they need to wholesale the contract, they can. And they basically want to be able to control that transaction and have multiple ways of, closing and whether it's, closing themselves or through another end buyer. And they're real good about that. But what they're not so good about, and I've seen this come up now multiple times, is making sure that the final documents, especially on subject to transactions or seller carry transactions, making sure that those documents, the resulting documents from the transaction, have proper assignment provisions, which give the buyer the flexibility to do a disposition of the property later on. And what I mean by that is I see where, the purchase contract is fully assignable and hopefully has language in there that says that the resulting wrap, note, and deed of trust will not have a due on sale clause. But then what happens is they go to the title company. The title company prepares their standard promissory note and deed of trust and loan or mortgage. And lo and behold, that deed of trust or mortgage has a due on sale clause. Well, now the investor has this property, and they really have one of two options to make it work, to make sure that they don't, go sideways of that due on sale clause that's now in the favor of the seller. So either you can lease the property, or if you want to sell the property, you cannot then sell it on a wrap transaction. You cannot sell it on an agreement for sale or a contract for deed. You have to sell it to a buyer who is going to come in and pay off the existing loans. Now, you can sell it on a wrap, but you run the risk that the original seller won't like that. And guess what? Now they have a remedy. Now you've allowed the seller to say, oh, no, I don't like what you did there. I don't like that you sold it to a subsequent buyer. And, now they're paying you. And then, you're paying my loan. Like, I really don't like it. We know that sellers have remorse. Well, you have a seller who has remorse, and then it's like, well, how do I get out of that? Oh, well, wait a minute. Your loan documents have a due on sale clause. And guess what? The buyer sold the property. And now you have a right to basically demand full payment of the loan or to foreclose. So you need to make sure that the resulting documents don't have that due on sale clause. And the same can be said on an agreement for sale. So you want to structure the transaction in a way that the ultimate transaction is through a contract for deed and agreement for sale. Well, does your agreement for sale or contract for deed have an alienation provision or a due on sale clause in it that would prohibit you from doing a subsequent agreement for sale, or that would prohibit you from assigning that agreement for sale to a third party? Because if it does, then once again, you're kind of stuck. You're a landlord, or you're going to sell it to an end buyer who then is going to, have to pay off the existing loans. But those are your exit strategies. You don't have the ability to potentially keep the existing loans in place and to assign that agreement for sale or to do a subsequent agreement for sale if there's a due on sale clause or an anti-assignment provision in that agreement for sale. So it's very important on your documents that you use to actually, acquire the property, the transaction documents, beyond the purchase agreement, that those give you the flexibility to, on the back end, do a proper disposition.
All right. Thank you, Sean. With that, before we get into our topic today, 2 announcements for the listeners. Announcement number 1, the Creative Finance Collective every Tuesday. So today is Tuesday at 3:00 p.m. Arizona time. So if you're watching from another state, make sure to adjust accordingly. But that's 3:00 Arizona time. What is the Creative Finance Collective? It is a group of professionals, mainly attorneys, that are attorneys that focus on the creative finance space. There's not a lot of them out there, and we get together to discuss the law of creative finance, what we're seeing from our different perspectives in different states, what the creative finance community is doing and what we're seeing. Gives us a chance to walk through that, see what's going on, but it also gives you a chance, the listener, to be a part of and interact with us for 1 hour during the collective. So what do I mean by interact? What I mean is it allows you, we're going to be taking questions throughout the entire hour. We're going to be captive to you for as long as listeners have questions. So if you've been wondering or running into roadblocks with creative finance or want to see how it is we might do this, or maybe just looking for a referral for an attorney in a particular state we might be able to help out with or recommend somebody, or maybe that person will be on there. It's an opportunity for you to ask those questions. There are no stupid questions when it comes to creative finance. Anything that you have, we're prepared to address. So 3:00 for the hour. Make sure to be there today and every Tuesday. Look forward to engaging with you in that. Also, today, we're talking about creative finance and the 5 things that you need to do or should be considering in adding to your contracts. So we're going to be taking questions, if there are any, in the final 15 minutes of today's episode. So if you have a question for our guest today, make sure to post it. We'll be taking, we'll record those questions ahead of time. So if you think about it as you hear us discussing with our guests a particular topic, make sure to just go ahead and post it. We'll take note of it, and we will address any questions that we have in that final 15 minutes. So with that, let's get into the topic today and what we're going to discuss. Today's topic is 5 changes for your creative finance contracts. And with us to discuss that topic is Alan Ceshker. Alan, how you doing? Good to see you.
Doing well. How are y'all doing? And thanks for letting me join.
Yeah, we're doing well. Always happy to have you. For those of our listeners who aren't familiar with you, give us a little idea about you, your law firm, your title company, what it is you do, and where it is you practice.
So we're main office is based out of Austin, but we close all over the state. We're a law and title office. Business model is we have the law office there to support the title transactions when needed. Hopefully not needed, but then if needed, the law firm comes in and fixes things. And since 2007, 2008, been focusing quite a bit on the creative financing, mortgage wrap, subtos, and all the wholesaling, and then recently novations. And so while many title offices during the downturn of their consumer retail transactions, they'll dip into this arena. We just dipped into it back in 07 and never left. So that's kind of our forte.
All right. Alan, I'm going to post a little barcode for the listener right above my head here. It is Rap University. Tell our listeners about Rap University.
So what we've done is taken our 20 plus years of experience in closing wraps, sub-twos, assumptions, and created a 4-hour program. It's actually CE certified, continuing education certified. And you would think 4 hours is a long time to talk about mortgage wraps and sub-twos, but when we get done, everyone says, "Dear Lord, that was fast and that was a lot." So it's a extremely comprehensive program that should take you from not knowing anything to being able to have the comfort to get into a contract for a wrap or sub-two, and then get that contract over to title, and hopefully title holds your hand and accomplishes it. But it's designed to get people investing in wraps and sub-twos.
Yeah, so if you're a listener and you're watching, we posted the barcode. All you have to do is scan that barcode. That'll take you right to Rap University. It's a good program, and it's not even the kind of program that just investors have to go to. Our own Sean St. Clair's been to the program and can vouch for it as well.
Absolutely. Yeah, it was great. I flew to Dallas and learned so much in the program. A lot of it is Texas based, but then there's some general principles, some contract language, some other things that are I definitely took away, went back to Scottsdale and made revisions to my contracts as a result of being there. So it was well worth it. And I recommend anybody that's, in the space of creative financing to definitely register, sign up, travel, meet in person. I know Alan has an online version as well. I enjoyed being there in person. He had multiple guest speakers, one of which was his insurance agent that he recommends to, handle these transactions from the insurance side. I've referred a lot of clients over to him already as a result, and he's been invaluable. I've received great feedback. So, those types of things you can't really replace with the in-person version, but or not the in-person, the online version. But if you can't make it in person, do the online version. But otherwise, definitely try to get back there to one of the cities that he's hosting it in. It's invaluable, and it's well worth your time and money for sure.
We actually have the very first, so it's live in Austin, but it's going to be available via Zoom on February 17th. It's our first time to try it via Zoom. We'll see how that goes.
Yeah. All right, Alan. So let's get into talking about creative financing. And I think as we break down what you would recommend or think are the 5 changes people should be thinking, or maybe even more changes people should be thinking to make to their creative finance contracts, I want to lay a little bit of groundwork. So if somebody's watching and they're new to the topic, and I think there might be a lot of those folks because it's a growing kind of phenomenon, right? The market conditions encourage this to continue to create or to grow in popularity. So for somebody new to what we're talking about, how would you define creative financing? What are we talking about?
So initially we're talking about, I would say seller financing. We're very often talking about unrepresented parties, no real estate agents involved. But once we get past seller financing, then we're immediately talking about the mortgage wrap sub-two. We lump in other items, wholesaling, novations into the creative finance arena. I don't think they strictly fall into there, but they're lumped in also. But the great majority of what we're looking at is sub-two acquisition to acquire property from distressed sellers. And then the disposition is a seller finance wrap out of that. So now you have a cash flowing transaction. That's the most often used investment method. But as I always say, once you acquire that property sub-two, any exit strategy works. It can be a short-term rental, it can be a conventional sale, long-term rental, what have you. But the great majority of our work is sub-two acquisition and seller finance disposition.
Now, you mentioned a lot of these can or may be done without realtors. real estate agents. A lot of that might be because agents aren't comfortable with the transaction, or maybe their comfort level is just because there's a lack of familiarity with the transaction.
Yeah.
That means you're not going to have access to oftentimes standard forms that real estate agents have. And the contract's important in every transaction, but especially in a creative finance transaction. Why don't you break down, for those just learning what creative finance is, the common pieces of the transaction in terms of contracts and disclosures that they're going to need to, terms that they're going to need to start becoming familiar with, and what they do.
Good deal. Good deal. I was trying to rank my 5 items, which one was most important, and all I did was just kept taking the third one down, putting it first, and then the fourth one and putting it first. So I think they're all important. But I think what ended up on number 1 is, in fact, when available, use your state promulgated contracts, period. I don't care what contract you have. I don't care what attorney assisted you with it, especially the ones that are supposed to be one size fits all states. They're just not going to be as good as a state promulgated form. So ours is called the TREC 1-4, Texas Real Estate Commission 1-4 Family Purchase Agreement. And so I think step 1 or rule 1 is use that contract. There's no reason to go out there. A lot of times people will send me a little 2-page contract and say, I like this one because it's shorter. Can you make this one so it's good for Texas? And I tell them I'm going to copy the TREC 1-4 contract over here and delete what you have in there that's not the TREC 1-4, and then charge you 4 hours of time if that's what you want me to do. But in all seriousness, there's no reason to recreate that wheel. So step 1 on getting a seller finance transaction, once you have that seller educated or that agent educated, is to get that TREC contract, or any of the state contracts going to have the same thing. You've got your down payment, you've got your loan amount, and then you have the total. And that's about as complex as it should get right there.
Well, and we've discussed this, Alan, which is Texas and some other states are unique in relation to, say, Arizona, in that your real estate department has promulgated forms to be used by anybody. You don't need a license, or you don't, it's not subject to copyright or anything like that. Whereas here in Arizona, we have the realtor forms, which only realtors can use. And those are our only standard forms. And then everything else has to be attorney created, basically. So let's talk about Texas specifically. If you have a seller in Texas who owns the property free and clear, and they want to do seller financing, and they came to your office and said, okay, what contracts and addendums do I need to make this happen? What would they be looking at in Texas?
So just simply the TREC contract, and then you're going to have the seller finance addendum, because we also have that state promulgated form. And a lot of times they're asking me to complete this contract for them, and I can bill them a couple hours of time to write in the name, write in the address, get the abbreviated legal description from the CAD. I can charge them a couple hours of time, but I don't. I kick it back to them and say, fill in all the basic information. Who's paying for the survey? Are you getting title insurance, this, that, and the other, and then ship it over to us with a narrative of what the intentions of the parties are. And it takes me literally 5 minutes to go through that contract and confirm that we've captured those intentions. So I don't even bill for that anymore. If they're closing with us, it's just kind of a part of the service. And then the seller finance addendum it's relatively simple, a little bit more complex if you're absolutely new to seller finance concept, but you're just describing the new note. How much is the note amount? What's the interest rate? What's the amortization? When's the balloon? And that's what's in there. You have to make a couple other selections in regard to escrows. Should escrows be kept? My answer is always yes. Is there a due on sale clause, or do you need consent to sell it? Whenever I'm selling it, I always click off yes on that. I've never prevented someone from selling it, but I just want to know about it. So those items need to be checked off. And then the last item is going to be up at the top. What type of ability to repay or credit analysis needs to occur, and you just check off what you want on that. So it's substantially simple. But again, your title office, it's always kind of a joke. You can bring them a napkin that says, I want to sell my property to John, and we can advance with that, and we'll fix it on the way. But it's easy. Contracting is easy.
Right. Well, one of my biggest takeaways from Rapp University was the use of the TREC form, but the use of it in the subject to transaction. And that's where, you kind of showed us a little bit of the magic as far as the changes that your office has to make to some of these forms to make them work for really the Rapp or subject to transaction. So let's talk a little bit about what forms would you use in Texas for a Rapp transaction, and what kind of changes would you generally recommend making to those forms?
So on a Rapp, we're really only adding a disclosure that it is a mortgage Rapp transaction. So we've got paragraph 11 special provisions. Everything else, and I try to demystify mortgage Rapps, especially because they are simple. You can completely forget about the fact that there's an underlying mortgage in your TREC contract because it's not mentioned. The only thing that you may mention is the fact that, hey, this is a mortgage Rapp transaction. Underlying mortgage has a deed of trust that has a due on sale clause. The lender has the right to call this due. I like over disclosing that in paragraph 11, but even if it's not owned free and clear, your contract is still completed the same way. And then you're going to identify that mortgage in other documents, but your contract is the same for Rapps, a little bit different for sub-twos, but same for Rapps.
So laying the groundwork as we have, let's jump into the top changes that you think investors should look at making to their contracts. And maybe they're not just changes, maybe they're just additions. I guess that would be a change, but what they need for their contracts. Now, it sounds like you've already identified number one. If that's true, give that one to us again.
Yeah, the top thing to change about in your contracts is use the right contract.
Or use one, yeah.
Yeah, and you brought up a good point about Arizona not having a promulgated form, but I would suspect that the attorneys have probably gravitated towards a bit of a standard type contract that floats around. I would hope.
I wonder who might have drafted that.
So
yeah, there kind of is here in Arizona. So the little bit of work we do on self-assisted closings, I see the same contract on a regular basis.
We'll say use your state promulgated or your popular attorney promulgated form.
Yeah.
But then the first thing to include, and this is Texas specific, because we had new law changes a little while back, and they came in and we've always had what's called the 5016 disclosure, Texas Property Code 5.016. And all it is the nuts and bolts of the mortgage that's going to be wrapped. So it talks about the lender contact information, talks about the interest rate, talks about balloon date, insurance, taxes, and it's the items that need to be in that 5016 are hard coded into the statute itself. So it's not a form that you have to go and figure out how to create. But what the laws did, they amended property code and finance code to say if you're not providing that 5016, and this is on your sales side, and if it's your fourth one in a 12-month period, and you don't provide that, then that buyer has the right to rescind that contract. They have the right to rescind day one after close all the way up to day 30 years after close. And so it's pretty problematic. Mm-hmm. So obviously it's going to come up as a problem when you have a default situation and you're attempting to recover your property, and then some smart lawyer comes along and says, well, we don't have our 5016 disclosure, so I'll come free. We're just undoing the contract. So that's probably going to be up there in my number one or number two area, is use that. And you can use the same one all over the U.S. Again, the issue is disclosure. make sure everyone knows and has full expectation as to what's going on. Well, that 5016 is just one of the disclosures that we do now.
All right, that's our number one. Let's go to number two.
So my number two is a new one. You hear about the due on sale clause. We used to be able to 99.8% diminish the importance of that by saying it just never occurs. I think because of the prevalence of these subto investors, they're getting a little bit clunky, and mortgage companies are looking a little bit more. And so we're going back to closing our acquisitions in a trust vehicle. So we have it's called the Texas Land Trust, but it's not a statutorily created vehicle. It's just by use in common. So we're going back to that land trust where you place the property into a trust. The borrower is a beneficiary, and so that gets us safe under the St. Act. And then, I won't say what we're doing with that beneficiary interest after that, in case there's any mortgage companies watching us. But obviously, the control of that trust then goes over to the investor, and it keeps us now back up to 99.9, if not 100% protected from any due on sale clause issue. One other reason we're doing wraps are coming into the mainstream, retail industry of real estate, and so end user seller to end user buyer is a little less resilient on dealing with post close due on sale clause issues. So we want to try to avoid them before they bubble up.
So this is, to be clear, when a lot of folks hear land trust, they think, oh, well, we do that or have been told to do that for anonymity. That may be a benefit, may or may not be, but it doesn't really sound like that's the reason that you like using the land trust. You mentioned the St. Act, that this is, in order to make this be in compliance with that act to look like an estate planning technique.
Yeah. And it could be a simultaneous estate planning. However, the trusts that we're getting in place are sole purpose trusts. And because of the need to have control by the investor, they're going to be called a passive trust, and therefore not providing liability protection. So it's definitely not a substitute for estate planning. And I've never been a big guy about, hey, let's stay anonymous. If I want to sue someone, I can find them.
Yeah, right.
And if they make it hard for me to find them, now I'm suing their entities, and they have to start trying to get their entities out of that lawsuit. I don't know. Let's pull our swords and start fighting at the get-go. But if you want to hide your properties, you do need that anonymity also.
So give us number three.
So my third one's not necessarily, and we've talked about this on the collective before, is it's not necessarily for creative finance exclusively, but we have such, again, so many investors out there going around. We end up with these disputes in regard to earnest money and conventional transactions too. And so I've crafted some language, and I can copy and paste it into the chat section to y'all, but it's not rocket science. It's just it won't let me put the whole thing in there, or maybe it did. It's just a release and indemnity to our office and the title insurance underwriter that says we can release the earnest money to buyer or seller, and buyer and seller release us from any liability in regard to that, because we'll have buyers terminate during the option period. And then the seller says, no, they drug this on too long. Like, well, but you have an option period. They can terminate. Or vice versa. Buyer says they're not going to close on the transaction for one reason or another, and they're refusing to get that earnest money over to seller. And we want it out of our escrow account. We don't want it there. So what I've done is created some language that allows me to act with some release of liability. Now, if you have yourself a $50,000 earnest money over there in a commercial contract or what have you, probably going to be a little less likely to willy-nilly go out there and start releasing that without both parties. And again, I don't think y'all run into this problem because y'all are actually allowed to release. But in Texas, the second anyone says no, don't, we can't.
Well, and that's true in Arizona too, right? If a party comes back to title and they have a good faith basis as to why there's a dispute as to the earnest money, then title just says, oh no, and they will actually go and I think it's called implead or interplead. They basically put it on deposit with the court and ask for their fees, But and I am curious about this because we've had other title people on or closing attorneys on the collective, and they were like, "Oh no, we are a mutual release state, or we require 2 signatures to release any earnest money, even if it's canceled in the inspection period." And in Arizona, basically, what happens is if it's in the inspection period, and even if it's a large earnest money on a commercial deal, if it's in the inspection period, the buyer delivers notice to the escrow agent and to the seller and basically says, I'm canceling, please, refund the earnest money. And title will, they don't expressly state this, but they'll hold it for a day or two just to see if, the seller comes out of the woodwork and is like, oh no. And if they don't hear anything from the seller, they'll just release it. They don't require the seller to sign. They don't require, any acknowledgement or otherwise. They'll release it according to the contract. Now, most purchase contracts have the indemnity language that you're talking about in there as far as the release goes. But do the underwriters in Texas require generally that you get 2 signatures on the termination to release the earnest money if the buyer cancels in the option or inspection period?
So it used to not be the way it is now. And I think it's just been a matter of practice where there's been problems. Underwriter rolled in, said, hey, don't do that again. That information gets around, but there's not even, I don't believe there's even an underwriter bulletin advising us on this, but it's the absolute state of the art practice now. We're very concerned about it. I actually had a case, title office released the dollars to the wrong party. It was a bit of an accident, and we rolled over, and that agency had to pay my guy $5,000.
Wow. So what do you think about this to get around that? Because I know buyers get very frustrated because these sellers then think that they have leverage and they're like, I'm not going to sign the release, even if they have no good faith basis, to not sign. They just, create an issue. What if is a way around that? And I'm really just worried about the inspection period, right? Because that's what you've contractually agreed is, hey, if I don't like what I see with the property or the title or whatever, I can just cancel in this inspection period. What do you think about in that case, in states like Texas, where the underwriters are starting to get, strict and want 2 signatures? What do you think about having a provision that basically states that the earnest money is not deposited until 2 business days after the inspection period?
So I like that. I also like earnest money is released over to seller after the inspection period ends. I like either one of those. Actually, that was, I believe, 4B on my little list here.
Okay.
So you hit it. You looked ahead. One of the things I really like to do in terms of the wholesale, when there's an assignment fee or non-refundable assignment fee, is have those released over to the assignor, and don't get it locked into title. Because same as earnest money, those assignment fees, even though it says non-refundable, if both of them are claiming it, then we're locked down. So I like releasing things to the parties when you can.
Oh yeah, good point.
So has earnest money disputes been a growing trend? Have you seen more of them as subto deals have become more prevalent?
For me, I don't think I've seen more necessarily. We've always been fighting over earnest money. When you find a loophole in the contract that lets a buyer out, some number of days weren't filled in, so therefore they have the right to object up till time of closing. People don't like loopholes, and they'll start fighting, and they've always been doing that.
Got it. So give us number 4, the number 4 change or addition to the creative finance transaction.
So y'all started by talking about wholesale a little bit. We had some law changes, and so I want to include that since it's in the creative investing arena, if I can. But we had a law change, and so now the statute was changed so that if you're going to sell your equitable interest, you used to have to disclose, obviously, to the end buyer, hey, I'm not selling the property, I'm selling a contract, I'm selling my equitable interest or rights to the contract. Now you have to advise the sellers that, hey, I'm going to go wholesale this thing. And personally, I like that. I don't know if it's the same there in Arizona, but in Texas, you get attitudes with sellers saying, I didn't contract with Bob, I contracted with Don over here, and I ain't selling to Bob. Well, contractually you have to, but that doesn't mean you're going to. So the new law change says you have to say, I am going to go and sell my equitable interest in this contract. And so I do like that change.
Yeah, so we had a similar law pass a couple of years back, which requires that the contract disclose that the buyer is and the language that the statute requires, a wholesale buyer, and who is going to potentially assign their interest in the contract for a profit, and you have to put that in the purchase contract. And if you don't, then the seller can cancel at any time prior to closing. So once it closes, it's closed. That's it. But up to closing, they can cancel and retain the earnest money. And that's the consequences. There's no civil penalties or anything like that after that. What are the penalties in Texas if somebody, fails to disclose that? How does that work?
See, they didn't come in and hard code that into our statute. Y'all statute actually says seller has right to terminate.
Yeah, prior to closing.
That would have been fantastic. I think that's going to be the end result. If something was taken to trial, taken to court, I think they're going to say, well, yeah, you didn't disclose, and so therefore seller can terminate. But they didn't code it into the statute.
So then what's the penalty? What happens if a buyer doesn't disclose it? Is it damages? Is it, administrative action? What happens?
So I'd be hard pressed to figure what your damages are.
Right.
I think this will gravitate towards having the seller has a right to terminate, but not damages. Maybe keep the earnest money. I guess they've kept it off the market for a bit, but I'm not certain what damages would be. You can't say I was under contract with them and they didn't tell me they're going to wholesale it, and I have another buyer over here who's going to pay more money, so therefore I'm damaged. That's not the way it works, but I don't know. Maybe they'll come back in. This is the second time they've come and tweaked the statute, so I guess maybe we'll have a third.
So I have a question, and I don't know if Texas is doing this, but I know some states are starting to look at this. What is Texas's view on the assignment of a subject to purchase contract as far as the assignor's role in the transaction? Are they required to, then because they're kind of the middleman in the transaction, comply with Dodd-Frank and RESPA and all those things as, basically a loan originator? Or are they, basically just selling the contract, and then, the parties to it are the buyer and seller, and then they're not really deemed kind of in that middle, thing as far as loan origination and stuff?
So what is it? It's January 30, 2024. I'll give you my answer as of today.
Okay.
It may not lie. I always advise my investor clients, if you don't go into title, so if you're not doing an A, B, B, C, a double close, simultaneous close, then you're decreasing your liability considerably. So I think if you assign it over, you're not subjecting yourself to Dodd-Frank, Senate Bill 43, and all those requirements. I don't know if a court would find it different than me, but as of today, that's the advice I give.
Yeah, I think that's the consensus nationwide, although I know there's some states that are, there's a few rogue states that have tried to say that wholesaling requires a real estate license based upon the
yeah.
current statutes on the books, only to have a court say, no, that's not what the statutes read. But nevertheless, it's those rogue states that are now like, oh, well, can you assign subject to, and what does that mean? But I agree with you that, at the end of the day, the seller is the one that would be subject to any Dodd-Frank. And if it's an individual seller who's only selling one per 12-month period, I don't think Dodd-Frank would apply in that case, even if the contract was assigned.
I agree 100%. And the state laws for us, if it's homestead, then it doesn't need to comply with the statutes, even if you sell 2 homesteads in the same year. But I do think that, personally, I think that Texas and all states are going to start trying to regulate wholesaling more and more and more. And that's why we're early adopters of the novation system to get around that.
It does seem like there is this thought, or it appears to be this case nationwide, that if there's one area of real estate investing or real estate law, wholesaling has the attention of the state legislatures more than anything else, at least right now, probably because of real estate agent lobbies and different and whatever else, and with the idea to protect individuals, so on and so forth. But that has seemed to have garnered a lot of state law attention. And so even more of a reason why number 4, wholesale disclosure language is really important. And I know that, we all preach this in all forms of creative finance, regardless of what your state says, but you really can't go wrong with disclosure, right?
Yeah. Yeah. And I think a few bad apples are fueling the fire and giving some legs to the real estate lobby folks. And I think that'll probably continue.
So give us number 5, the number 5 addition or change to a creative finance contract.
So,
you think investors should
escrow analysis. You have kind of different levels of taking a look at the tax and the insurance escrow. If it's a subto acquisition with a distressed seller and you're paying the reinstatement, you don't really need to look at it that much. You still need to take a look at it because there could be a escrow analysis coming pretty soon from the mortgage company because there's $6,000 over there in suspense, what have you, and they're going to increase their monthly payment. You need to know about that if your intention is to go seller finance that thing, or know about it to see if it runs your deal. But then when you start going and looking at the mortgage wrap transactions, even if you're buying as an investor via mortgage wrap, you've got to analyze that escrow account. So it is going to be either ahead or behind. It's never the exact correct. 7 months. On July 1, you've got 7 months, right? 7 months of escrow. So you got to do that analysis and true that up on the settlement statement. And then lastly, you got to take that insurance portion of that escrow and take it out of the equation, because that seller is not going to be buying another insurance policy, and so they need all of their months of escrow of that insurance escrow portion at least to be refunded. And again, this kind of stems from some of the consumer transactions. If you're not paying attention to this, they're usually expecting the title office or the law office or what have you to do it for them, and we're not. It's a negotiated item. Do you want to prorate your escrow? Check off yes or no. Not we come in and tell you what you're doing. So take a look at the escrow accounts, number 5.
So I want to follow up on that because you raise an interesting issue here, which is, and I think this is kind of even a recent phenomena that we're seeing, which is, well, if the seller funded that impound account for however long, and they are then assigning insurance and giving a POA to the new buyer, there should be something in the contract that says, insurance is not prorated at closing, and the seller assigns that impound account to the buyer, right? I mean, is that what you're talking about?
Yeah. So the escrow account is assigned, but then in our contracts, it also says there is a proration that's to occur. And so we kind of luckily, the existing contract does take care of us in terms of what's needed. And I guess we should back up. Obviously, in a conventional transaction, that underlying mortgage is being paid off, and so you do have to prorate those things. In a mortgage wrap transaction, let's say that the escrow account is spot on. Well, there's no prorating because seller paid their amounts up to close date, and then buyer takes over and starts paying their amounts post close date, and so everything's fine if the account's trued up.
Right.
So I agree 100%. It definitely needs to be addressed in the contracting.
So do you put into your contracts now that, is your suggested language for the contract now that insurance and maybe taxes are being paid as well? Insurance and taxes are not prorated at closing?
It depends. If it's a seller finance wrap, then yes, they're going to be trued up, not prorated. We'll call
Okay.
it. In a subto, it's completely different. If seller's distressed or what have you, what I tell my clients is take care of it. I don't know which way you need to take care of it, but get your escrow analysis. You can get that just as quick as you can get a copy of the reinstatement. And y'all need to negotiate how you're truing those numbers up.
Makes sense.
So those are our top 5. Alan, you mentioned you might have more. Did you have additional ones beyond changes beyond the 5?
Let's look here. Well, we hit upon it. One of them was the release the earnest money, and then I guess generally what I want to say is in every single wrap and subto transaction, have a general disclosure in your special provisions that does talk about the deed of trust that's being wrapped. There's a due on sale clause. Lender can call the note due. I want that disclosed in the contracting. Should have been disclosed even before the contracting, but then definitely during that contracting.
Are the disclosures different depending on who the buyer is? And what I mean by that is, when you have a consumer seller to an investor buyer, there's certain disclosures that I believe should be in there for the seller. But what about when you have a consumer buyer? Or what kind of disclosures, are those different? Additional disclosures for a consumer buyer? I mean, what does disclosure look like in that case?
Well, so investor buyer is going to be subto most often, subto acquisition, and there's almost no disclosure going on there. Seller's not disclosing; they're
right.
They don't know. So yeah, there are just by practice, not necessarily by rule. There are substantially different disclosures for a seller finance wrap versus a subto acquisition.
Mm. So what about a situation where, let's say that, and we've talked about this, the idea of assigning a wholesale, assigning a subject to contract but let's say your end buyer is a consumer under that, right? So you have a consumer seller. I'm an investor. I put it under contract. I put in the, subject to terms. And then I end up finding on the back end an end buyer that's actually a consumer buyer. Are there disclosures that should be made in that case, by the assignor to the assignee? And what would those look like?
Dear Lord, yes. The problem is, if it's not someone that's getting advice from an attorney, we don't know what investor A, B, or C is doing. So
right.
When we get the contract, because there's not a disclosure requirement, it doesn't have to be in the contracting disclosure, you're going to sell your equitable interest. And then some people aren't doing it at all. But we think party A is the buyer. And so we don't get to advise them, hey, if you're going to assign this out, you need to, and here's some sample disclosures that you can use. It would be good if we knew, but we don't. And so it creates a problem for the title office because a assignee comes in, doesn't fully understand the aspects of what's going on. And we also have it on the seller side. Seller comes and says, I thought my mortgage is going to be paid off. And then I'll ask the investor, where's your written disclosure, signed off disclosure on this? And well, we don't have it anymore. And we've had them post-close where they say, I didn't know my mortgage wasn't going to be paid off. I ask, all right, where's y'all's disclosures? Now, there's a substantial number of disclosures in my documents, but I will agree that there might be some folks who are signing documents and aren't reading them all and don't understand them all. So we had one VA loan. The guy said, well, I want my entitlement. I need my mortgage paid off. And so they had to renegotiate, make it a 2-year transaction versus the remainder of the mortgage. But lack of disclosure is bad.
Mm-hmm. Yeah. Yeah. You want to make sure that end buyer understands that they're taking it subject to. And if the lender, discovers it and wants to do something about it, that, you could lose your interest in the property, in short order.
And at the end of the day, in my teaching, I always say we've got things wired pretty darn good. Have Plan B, and Plan B needs to be pay off the mortgage in some form or fashion via sale, refinance, what have you.
Right.
We have a question, Mayu. Why don't you go ahead and read out our question to us, or post it for us? Can the buyer take cost seg depreciation when buying on land trust?
So that sounds like a tax question.
It does. Lawyers don't like tax questions.
No. All I can speak to is what we've done with the trust is make sure that you can still have your homestead protection, both the liability protection as well as the tax exemption. But that tax question is going to get uncomfortably a little bit outside me, unless y'all guys know.
No, I don't know. I don't. In Arizona, because of our state statutes that require the disclosure of beneficiaries of trusts on every deed, we don't do land trusts, and that's not the way that these transactions are handled. So I'm not sure I know the answer to that. I would say reach out to your CPA and say, hey, look, here's how this transaction is going. I'm going to take over the beneficial interest of this trust once we close on the transaction. Can I have my LLC that becomes the beneficiary of the trust claim that depreciation? I don't know the answer.
Yeah, I'm the same. I'm not a tax attorney, not familiar with that. That's where you would want to confirm that with a CPA. Mainly, again, the reason, and correct me if I'm wrong, Alan, the main reason you like that as one of your top ones, at least at what you were seeing in Texas, is to try to comply and look like, or comply with the Garn St. Germain Act, right?
Yeah. And we 100% do comply, at time of creation of all documents, certification of trust and what have you. The only way something can go south on us is if there's actually a lawsuit where discovery's occurring and they're requesting and demanding documents that we don't have to provide otherwise, if it wasn't a court situation. And so I don't see it ever rising to that level. So we should be 100% protected.
Well, Alan, thanks so much for joining us. We really appreciate the time. While you tell our listeners how they can connect with you, I'm going to post your Rapp University barcode here one more time. If you're interested in Alan's Rapp University, go ahead and scan that on your phone, and that'll take you right to it. But Alan, how can our listeners connect with you?
Best way is just go to our website, which is mylastname.com. So CESHKER.com. And that'll have everything you need if you want to take a look at Rapp University or get with my teams or get with me. So it's CESHKER.com. I greatly appreciate y'all having me on. I'm a geek. I'm a rap geek, a creative finance geek, and love talking about this stuff. And we like receiving questions from folks. Most attorneys don't want a question because they're not billing anyone. I do, because I create a database and keep that database filled.
Yeah. Well, thanks again so much for being with us, Alan. We really appreciate it. Great information, and look forward to doing it with you again.
You bet. Thank y'all. Thank you very much.
All right.
Thank you, Alan.
Good one.
Bye-bye.
With that, everybody, that is our show. Thanks for joining us. Make sure to join us next week, and make sure to join us this afternoon live at 3 p.m. Arizona time for the Creative Finance Collective. We'll see you next time.
Have a good day, everyone.